Welcome everyone. We'll just give it a minute while everybody comes in through the digital space. So nice to see some of your names appear here in the attendees. All right, the number seems to have slowed down a bit, so I'll start with the introductions. I'm Christina Lemieux, she, her, and the lead producer at Generator. Generator does our work and is based off of the lands around Dagarundu, which is the lands of the Mississauga of the Credit First Nation and other Anishinaabe nations, the Haudenosaunee Confederacy, the Wendat, and other nations and peoples recorded and unrecorded and acknowledged and unacknowledged. As we are in a time where we can join globally from all over and wherever we are. If those lands are not where you're situated, you'd like to share with us where you are, then I welcome you to do so in the chat, as I will myself, as I no longer live in those lands. I am so thrilled to welcome and work with ALAS, which is Artist Legal Advice Services. And I'm so thrilled to be able to introduce you here to Kat Lovricks, who is a partner at Marks and Clerk Canada. I was connected with Kat a while back when we were reaching out about how to do a webinar that we did a few weeks ago on board governance. And that will be available in the blog for everybody coming up soon, and was blown away by Kat's wealth of knowledge and interest in intellectual property, and are thrilled to be able to welcome Kat back to work with us today and to do a bigger and more fulsome talk on intellectual property for the performing arts. Kat will have a presentation for about 60 minutes, and then we'll have a 30-minute talk back after that, which will be facilitated by you adding your questions to the Zoom question and answer function, which, if you haven't seen before, is along the bottom of your Zoom toolbar. I'm also just going to note that this is being recorded for the purposes of, again, sharing it on our blog afterwards, but the question and answer period at the end will not be shared publicly, although the recording may remain on for various reasons. Just know that that section will be private and allow us to speak more frankly about experiences and situations that people have specifically. I think that is all of my action items. Kat, I turn it over to you, and thank you again for joining us today.
Thanks so much, Christina and Annie and Kesha, for having me. We're very excited, as is ALAS, for collaborating with Generator TO on these. So today's talk, as Christina mentioned, is about intellectual property. I will start by saying that there was a number of really great questions that came in advance from some of the attendees. And what I'm going to do in the talk portion, or the presentation portion, is to give more of a sort of very high level overview of intellectual property issues, focusing squarely on both trademarks and copyright. I won't dive too deep into issues relating to patents, designs, personality or publicity rights, or confidential information. And then in the discussion period, if you happen to submit a question in advance of the talk and you're comfortable raising the question again, we can go over it and aim to address it. I just thought we'd start with sort of a general presentation before diving in. So I have a deck, and I will aim to screen share, which will hopefully work now. Did that work? See that? Christina, do you know are you able to see it? I'm going to presume. Oh, perfect. Okay. Excellent. Thank you so much. I am Kat Lovricks. I'm a lawyer and trademark agent. I've been practicing for 15 years, exclusively in the area of intellectual property, as well as marketing and advertising law. My practice focuses on clearance issues. So when you're using someone's property, what do you need to think about in order to make sure that whatever you're using is available for you and you're not going to trip up on someone else's rights? Protection. So when you're developing something, what sort of protections arise naturally, and what do you have to do in order to enhance your own protection or to secure a certain form of intellectual property protection? Enforcement, which obviously is enforcing your rights against third parties. I also do work when it comes to licensing, distribution rights, acquisition, as well as co-branding, partnerships, and sponsorship deals, as well as other sort of collaborations between different entities. because this is a legal presentation and us lawyers are overly concerned about disclaimers, I thought a disclaimer would be a natural place to start. This presentation is for your educational purposes only. Nothing should be taken or relied on as legal advice. Any views that I today are mine. They don't really reflect those firm, or you can hold me to account, but nobody else. And any unauthorized use or prohibition of this or reproduction of this presentation is prohibited. I'm getting a little pop-up saying my internet connection's unstable. Christina, pop on if I drop off. Hopefully it's okay. It is the last week of school and everybody is sharing the internet, as I'm sure many of you have experienced. And finally, the law is jurisdictional, and I'm a Canadian lawyer. While I do practice and manage matters internationally, working with lawyers around the world, it is important to sort of claim my perspective, and the views I will express today are primarily Canadian. So before we sort of dive a little deeper into trademark and copyright issues, I thought I'd level set for a moment on the different types of IP. So trademarking and the copyright for your patent design, all of those different things are quite different, and they aim to protect different things. So starting off at the top, very basically, trademarks, they really are the things that tell people how to know your goods and services are yours. They're signs that indicate source and quality of goods and services. And in terms of the type of protection, if you secure a registration, the registration in most jurisdictions, including Canada now, will last 10 years and is renewable potentially indefinitely. Trademarks in Canada and a number of other jurisdictions around the world arise automatically based on reputation or common law rights, although in some countries you do need a registration in order for a trademark rights to be recognized. In terms of costs, they're free in the sense that if you don't actually file a trademark application or take any steps to register your mark, and you market it and you use it and you start to build reputation, the investment you've made in your marketing and reputation building will give rise to trademark rights. And in the sense of the acquisition of the rights themselves, you don't have to spend anything to do that, although registration is highly advisable. And we'll talk about that in a bit more, in a bit more detail. Registration is not required, but if you do it, there are benefits. In terms of what to do in NDAs and thinking about confidentiality, the key to trademarks is before you've actually launched something, ensuring that whatever name or mark you've come up with is kept confidential, because before you've acquired reputation or filed a trademark application, you really have no rights to enforce against anyone else. From there, we have copyrights, and we'll talk about those in more detail today. And those protect fixed works or expression from being copied. There's a number of related rights, and we'll unpack them in a bit. But really, copyright is aimed at protecting expression, while trademarks are aimed at protecting things that indicate the source of goods or services. Copyright arises automatically. You do not need to secure a registration, although there are benefits that arise. And we'll talk about who owns copyright, but generally speaking, copyright lasts for the life of the last living author plus 50 years. And in Canada, we're about to move to 70 years. Many other jurisdictions are already at life plus 70. You don't have to do anything for copyright to arise, as I said, but you can register it. Thinking about getting confidential an NDA in place really is before creation or before you do something. There's no protection available for ideas. From there, you have patents, industrial designs, and confidential information or trade secrets. Patents protect inventions. We won't be talking about those today. You do need to register a patent in order to secure any rights, unless you keep it confidential and nobody is able to reverse engineer it. Industrial designs are non-functional aesthetic elements. Historically, industrial designs protect the three-dimensional shape of something that appealed to the eye and was not functional in any way. Increasingly, industrial designs are being used to protect two-dimensional things that appeal to the eye, including two-dimensional apps or even potentially artwork. And then there's confidential information and trade secrets, which is, I imagine you can guess, protects things that are kept a secret. And they can that's the only way that you can really protect ideas, is if you keep it confidential. And if someone else comes up with the original idea and didn't do it by breaching your confidentiality agreement, there's nothing you can do about that. What's generally not protectable from an IP perspective? Ideas, factual information, a name, like a very short name, although there's exceptions to that from a trademark perspective, very short phrases, and there may be exceptions to that from a trademark perspective as well. Methods, and there are exceptions to that from a patent perspective. Generic plots, undefined characters, and non-distinctive titles are generally not protectable. So now we'll dive a little bit deeper into the copyright versus trademark balance. So as I meant, the copyright versus trademark forms of protection. So copyright, what does copyright really aim to do? Copyright aims to protect original works of authors from being unfairly copied. And originality really is the key to protection. And a work will be original. Original means two things. One, it means that it originated from the author. So there was a human that ultimately created it, although there is sort of varying standards in some jurisdiction related to machine-made works. Generally speaking, there must be a human author. And it must be original in the sense deemed by law. And there are different standards of originality depending on the jurisdiction you're in. In Canada, your work has to be the result of skill and judgment. In the UK, you need to have made some effort, so it doesn't need to be creative or result from skill and judgment. You just need to have labored or what's sometimes called a sweat of the brow standard. And in the US, there must be a modicum of creativity. And the balance that copyright aims to protect is, on one hand, to protect original works from being unfairly copied, and on the other hand, ensuring that we create a very rich public domain and make sure that ideas are free for all. So it protects expression, not ideas. It protects original works, and it aims to ensure that in time, we have a very rich public domain. So trademarks, what are trademarks worried about? As I mentioned at the beginning, trademarks identify source and they're a badge of quality. They aim to prevent confusion and depreciation of goodwill. Depreciation of goodwill is the reputation a company has built up in its name or mark, and it can be protected from things like dilution. So if you have a very famous mark and it's very distinctive, you can prevent people from, in different categories of goods and services, adopting your mark. So Coca-Cola potentially would be an example of that. It's a famous mark, and while it's known in the beverage industry, Coca-Cola could likely prevent a third party from adopting the Coca-Cola name or mark in association with completely unrelated goods and services. Tarnishment is also a form of protection that trademarks achieve. Now, on one hand, trademarks really are aimed at preventing consumer confusion. Trademark law historically was a form of consumer protection law that was aimed at ensuring that when a consumer bought a General Electric appliance, it knew that the quality of that appliance and the source of that appliance was General Electric, and that it would meet the quality standards the consumer had come to understand would be associated with the trademark. So born in consumer protection law, aims to prevent confusion. At the same time, trademark law aims to leave words and signs that are common and should be available to all in the public domain. So it's not intended to grant a huge, wide scope of protection. I use this image on screen to demonstrate just how powerful trademarks can be. If you use a mark consistently and you have reputation, you can see one mark or one letter from a well-known mark and identify the associated brand. So McDonald's, Amazon, Kellogg's, LinkedIn, General Electric, Subway, Target, Unilever, Rolling Stone, M&M, Airbnb, Realtor, and Kodak. And this goes to show just the power that a trademark can have if it's used and protected properly. So we'll start off with trademarks and we'll transition to copyrights. So what is a trademark and what can be a trademark? Words. So for our firm, Marks & Clark is the trademark. Slogans, protecting ingenuity everywhere, as well as designs. And more recently, trademarks have expanded to cover a whole series of other signs or things that consumers see that identify a particular source or associated very closely with a company. So animations like bumpers, when you turn on Netflix, for example, and the Netflix bumper appears, that animation can be protected as a trademark. The position of something on a product or on a screen can be a trademark. So if you think of sort of the quintessential Google search engine and it being a very clean white space with the Google search bar appearing in the middle and nothing around it, potentially that position could be protected as a trademark. Distinguishing guise is another word for trade dress or the getup of a product or packaging. So because we already picked on Coca-Cola, I'll leave them alone, but the Coca-Cola bottle is one example of distinguishing guise. And increasingly distinguishing guises have also been used to protect things like interfaces and the like. Sounds can function as trademarks. So the MGM lion's roar, the Aflac duck, for example, are trademarks, as can holograms. And we have new forms of protection for scents, tastes, and textures. And those are evolving. So the law there is a little bit unsettled. So you're at the drawing board for your business or your company or whatever it is, your product that you want to brand or come up with a trademark for. What should you keep in mind at the drawing board phase in terms of how to select a strong mark? Trademarks are not created equal. Some trademarks are inherently much stronger than others, and some trademarks are inherently more expensive and more difficult to protect. So the first thing you want to think about is what's the inherent strength of the mark or the inherent distinctiveness of the mark. And the easiest way to think about that is what's the association between the mark that you're adopting and the goods and services. So generic words are not protectable. Apple for apples, that's not protectable because that's the dictionary word for the term. Descriptive words, those are the second type of mark that are difficult, or the first type of mark that are the most difficult to protect are clearly descriptive or descriptive words. And generally speaking, clearly descriptive marks or merely descriptive in the US are deemed to be not registrable and not protectable unless you've acquired secondary meaning or acquired distinctiveness. So Sharp for televisions and screen products is an example of a descriptive mark, but over the course of time, and through substantial use and reputation, you no longer hear Sharp when you hear the Sharp mark or think of the descriptive nature of the word. Instead, you think of the brand. From there, you have suggestive marks, and that's where the word is associated with the goods and services, but when you hear it, you don't specifically know what the goods and services are. Most marks tend to fall in that category because marketers like descriptive and suggestive marks, legal and trademark lawyers like inherently distinctive or fanciful coin terms. And most marks do tend to land in the middle. So skip the dishes for meal delivery services is an example. You hear the skip the dishes, you have some sense of what the associated goods and services are, but you don't naturally or immediately know that it'll be a food delivery service. Those marks are inherently registrable and are sort of medium when it comes to the inherent scope of protection. The next type of marks are arbitrary in the sense that they're real dictionary words, but when applied to the associated goods and services, they have no meaning or association. Windows arguably is actually a suggestive mark and not arbitrary, but we'll leave it where it is. So Dove for soap is an example. Dove obviously is a dictionary term, but when applied to soap, there's no obvious connection. Apple for computers is another example. The strongest type of mark that you can develop inherently and will grant you the widest scope of protection are made-up words, fanciful, invented, or coined terms. Polaroid, Swiffer, Xerox, those are the strongest and best types of marks from a legal perspective. The other things you need to keep in mind when you're at the drawing board phase is your mark a generic name in another language? You're unlikely to be able to secure rights if that's the case. Is it a name? Is it a geographic place? All those things will present challenges and narrow the scope of protection you're likely to be afforded. So the key really is to select a mark that is inherently distinctive, but also that stands out from the crowd. That's the goal. The goal is that your trademark helps people identify your goods and services from others. And so keep that in mind. If you pick a common word that everybody's using, it's going to be more difficult for you and your mark and your goods and services to stand out from the crowd. It's very important to keep that in mind. And I do recognize that there's naturally a tension between marketing and legal here. And you will probably land, or many people land, or companies land in sort of the suggestive box, as I said, but just make sure that whatever it is you're selecting does sort of teeter towards being more distinctive and enables you to stand out from your competitors and whoever else is out there. So trademark clearance, so you've come up with a great name. You've thought about the comments that I made here. It is inherently distinctive. It's not clearly descriptive. It's not a name in another language. It's not a geographic place. You're pretty confident that it's inherently distinctive. How do you know that the mark's available and you're not going to trip up on third-party rights? The first thing I'll flag here, and I think it's one of the most important things in misnomers that many businesses have, is registering a business name, acquiring a domain name, or filing a trademark application does not clear a mark. It doesn't mean you have rights. And in fact, I think many companies believe that they secured their business name registration. As a result, they're good to go. And then when they face enforcement, try to wave their business name registration around, and that doesn't actually defend you from anything, and it doesn't prove that you have any rights. What is important is to search to ensure that nobody else is using a similar mark in the jurisdiction that you're interested in using your mark, and with similar goods and services. There are various types of searches. You could do a knockout search, which is sort of the easiest, which looks for the identical mark with the identical goods and services. You can do a more comprehensive register search where you look for phonetic equivalents like sound-alikes, translations, different same word, homonyms, synonyms, and the like on the register, and sort of cast a wider net to get a sense of who might come knocking. And then you can do from there a comprehensive search, which includes looking at common law resources, including the internet, business names, domain names, and the like. In my world, we do clearance opinions. So before companies will adopt a particular mark for goods and services, we undertake the search and we provide an opinion. If you can't budget for that, at least look at the Canadian Trademarks Register, which is publicly available, and do a few searches to see what you can come up with to ensure that you're not tripping over someone's mark. Do a few Google searches to see if someone else in your field or in association with similar goods and services is using a similar mark. And you can do the same thing for domain names. And it'll give you a sense of what's out there. It may not be, a bulletproof sense of comfort, but it'll get you where you need to, or closer to where you need to be. So why register a trademark? As I said at the beginning, registration is optional. You do not need to register, but it is highly recommended for at least your most important marks because you'll get significantly enhanced rights. Once you have a trademark registration, it's a sword. You can enforce it against third parties, and it's also a shield. So as I said, a business name registration does not shield you from using whatever the name is, but a trademark registration does shield you from claims of passing off. So it's pretty meaningful, particularly from the main trademarks that are at issue. Once you secure a trademark registration in Canada, you automatically get the exclusive right to use the mark in association with the registered goods and services across Canada. So otherwise, your rights will be based on where you have reputation, which typically is the geographic region that you're operating. So if you operate only in Toronto or in Ontario and you have goals to expand eventually throughout Canada, registering your trademark or filing an application is one step you can do in order to try to create a bigger zone of protection. Having a trademark registration facilitates lawsuits as well. As I said, it's a defense to passing off or a defense to claims against you. And it gives you enhanced rights. So you can claim depreciation of goodwill, which as well as infringement, which are claims that are only available to someone that has a trademark registration. The other thing to keep in mind is it's actually an asset. So depending on the nature of your company and what your exit plans are, registration is something that gets sold with the business, or you can license it or you can assign it, and it has inherent value. The other thing to keep in mind is that trademarks are use it or lose it. So you secure your registration. If you don't use your mark for a period of 3 consecutive years, someone can move to cancel your mark from the register based on non-use. So what to consider before registering your mark? You have a limited budget and you can't file for everything. Registration is optional. But you do, and here are some things to consider. So first, what's your budget and what's the cost benefit? Consider the likelihood of being able to secure the registration. If it's very unlikely you'll be able to register it because you have inherent issues, then it may not be worth it. What are your objectives? Is this mark a core part of your branding? Is it going to stick around for a long time, or is it short-lived? It takes typically 1.5 to 2 years to get a registration. So if you're looking at a mark that's only going to be used for a short period, it probably doesn't make sense, or it may not make sense to file. There may be situations where you want to file anyways, but generally speaking, if it's not something that's going to last for 3 to 5 years, that investment may not be worth it. French language, if you own a trademark registration, you get, and in fact, for trademarks period, you get a benefit in Quebec where you don't have to translate the English mark, provided the French mark isn't also registered. And then there's a series of other factors that may weigh into whether or not you want to register. So what's the process? As I said, you start by searching. Next step is to prepare and file a trademark application. You can go it alone. The Trademarks Office, Canadian Trademarks Office database is available to anyone. You can set up an account and file your own application. Once for your application, you need to decide if it's a word or a design mark, and then you need to identify the owner as well as the associated goods and services with which you intend to use the mark. And then now there's a pick list for goods and services, so you can identify already approved goods and services, which will hopefully speed up the examination. Once you filed your application, right now it's taking a very long time to get to examination, but the Trademarks Office itself will examine the application for technical things like, did you describe the goods and services in a way that's okay? And are there other little technical deficiencies? And they'll also examine for substantive things. So is your mark confusing with a prior mark on the register? Is it clearly descriptive? Is it merely a name? Is it a geographic place? And it'll issue objections. And then you have to arm wrestle with the Trademarks Office in order to get through those hurdles. Once you've done that, and once you're through that, the trademark application will be advertised for anyone in the world to oppose registration. And then there's a 2-month opposition period where third parties can come over or can commence a proceeding or request an extension time to commence a proceeding to challenge your mark from issuing to registration. If you get through that process, the registration will issue, and it lasts for 10 years, at which point you can renew it. There's a 6-month priority period, which means that from your Canadian filing date, you have a 6-month period to file in most other jurisdictions around the world and get the benefit of your Canadian priority date in the other jurisdiction. Trademarks really are first, well, there's some first to use exceptions. You getting to the register first does matter. And so that's a mechanism you can use to preserve your priority date or your filing date and defer costs. Trademark filing tips: file for the mark you want to use for the goods and services that it'll be used within the next 5 years. Don't go overly broad because eventually, as I said, you may be exposed to a non-use cancellation proceeding. If you file for the word mark, file either in all capital letters or in standard characters as you'll present it. Variation in trademark designs can render your registration vulnerable. So if you choose to file for a design mark, make sure you're really committed to the design. If you're not committed, filing for the design may not be worth it, because once you change the design, you may have to refile in order to preserve your rights. And you may want to claim color, although you don't have to. If you file in black and white, you get any color combination that's possibly available. Whether or not you file or register your trademarks, it's advisable to use the trademark symbol, the little TM symbol. MC is the French equivalent, although in Quebec and other French-speaking languages, they do tend to use TM as well, not the MC. And you can use the R in a circle if your mark is registered. Avoid using the R in the circle if your mark is not registered. And frankly, even if your mark is registered, you can still continue to use the TM symbol without risk. You also want to use legends that identify the owner of a trademark. So mark is a registered trademark of, name the company, and if it's used under license, indicate that it's used under license. It's important to use trademarks properly. You want to make sure that you avoid generic use. So Kleenex, Xerox, aspirin, a whole series of marks have presented challenges as a result. Velcro have presented challenges as becoming rollerblade as becoming the word that is associated with a particular good or service generically, as opposed to the brand of a company. And some companies have had to run campaigns in order to maintain the distinctiveness. You can see ones for Xerox and Kleenex on screen here. The best way to avoid generic use is to not use your trademark as a noun or a verb. Don't Google it, but use the Google search engine, which I appreciate is not practical, but that's the strict legal answer. And really, you should be using your trademark as a proper adjective followed by a common name. So Google search engine, or Xerox copy machine, or Kleenex tissues. And you want to be extra careful with slogans. So if you have a slogan that you're using for your business, those tend to be used generically or descriptively and just inherently present greater risk. So be extra careful with how you use them. You want to distinguish your trademark from the surrounding text. So put it in all cap letters, in different font, in bold, and follow it with the TM symbol. And avoid changing the design features, as I mentioned. And just to give you a sense, on the left of the screen here, you can see marks that were updated and were held to be upheld. And on the right, you can see marks that were updated and were held to be too big of a change to maintain the registration. And so there is an inherent risk with that. You want to monitor your reputation and guard distinctiveness. You've invested in building this brand. Keep a Bible, or what I call a Bible, of your PR coverage, your advertising, how much you spend, what your sales are. If and when you ever have to enforce against a third party, you having proactively gathered that evidence will be especially helpful to people like me that will be aiming to assist you. All right, so that's the trademark talk. We will transition on to copyrights now, which are a very different form of intellectual property, although they can be used together with trademarks in the right context. And both will sort of be a push and pull in situations to help build assets for a particular business or company. So copyright protects original and fixed works, and fixation is important. Fixation means that it doesn't protect just ideas, it protects the fixed expression of those ideas. So how you say things, and how you write them in either in paper or digitally, what have you. And copyright can protect anything from, I think when you think of copyright, you usually think of more artistic works, so artwork, photographs, images, music, but copyright also protects databases, websites, computer software, code, and it can be used to protect that really many people would not consider to fall within the artistic domain. In fact, copyright squarely falls outside of the artistic domain. So it is a very powerful tool that arises automatically upon creation, provided a work is original. And you want to keep this particular piece in mind as a natural form of protection that you're going to acquire for anything that you create for your business in fixed form. There are neighboring rights in other things. So as I said, copyright protects it protects artistic, literary, dramatic, musical works. Neighboring rights protect sound recordings. So you get, in the music context, there's copyright that protects the composition and the lyrics, the musical score. And then there's neighboring rights that protect the actual sound recording or the master itself as recorded. And those are an adjunct to copyright, and they're protected in a bit of a different format or way. Copyright also protects, neighboring rights also protect performances. And there was a number of questions that came in related to performances, and we can talk about those in the Q&A. But there are different rights that protect performances, and it's important to keep that in mind. Choreography can be protected. We'll talk about that in the discussion. And broadcasts also are protected by neighboring rights. And then as a complement to copyright and neighboring rights or other subject matter, there are technological protection measures, so things like encryption and even just a login, and then there's digital rights management information. And those things were introduced in order to protect, because copyright became a whole different animal with the digital world, and technological protection measures and digital rights management information help copyright owners protect their works in a digital format, and there's separate forms of protection that are afforded to those things. Another complement to copyright are moral rights, and moral rights are rights that are only vested with an author. So if you create something, even if you create it in the course of employment for someone else, you as the author will get moral rights unless you waive them. And those moral rights, and we'll discuss them in a bit more detail, but they include the right to have your work attributed to you or remain anonymous where it's reasonable, and to maintain the integrity of the work. And when you're hired to do something on contract as a freelancer for someone, it's important to keep moral rights in mind and to be conscious of whether or not you're waiving them. So to unpack that a little bit more, you have copyrights, which are really the economic rights. Those are the rights that you can give away, that you can assign to someone else. Moral rights, as I said, they always belong to the author. Copyrights are divisible for the purpose of exploitation, so you don't have to give away everything. You can, if you're dealing, or acquire everything. If you're dealing with a licensing situation, thinking squarely about what rights are actually required for a particular context is important. And often you'll see sort of blanket licenses or blanket assignments that give every right under the sun, and that's not required, and in fact is often inadvisable. It includes the right to publish, to copy, to perform, to communicate in public, which includes over the internet. And it also includes the right to authorize others to do these things. As I said, copyright arises on creation, and it's important to keep that in mind. So you get these rights regardless of whether or not you've registered anything, and they can be quite powerful. As an author, you also get moral rights, as I mentioned, and they only belong to the author. These sort of are born out of the theory that as an author, when you create something, part of your being is sort of infused or fused with whatever the work that you create, and you should have the right to have that work attributed to you in reasonable circumstances or to remain anonymous. And you should also have the right to control the integrity of the work, including the work being associated with products, services, or causes or institutions that are detrimental to your reputation or honor as an author. They're not unqualified, so these aren't blanket rights. The attribution right or the right to remain anonymous, as I said, is only where it's reasonable. And the right of integrity and the right of association are triggered only where a change or distortion or an association with some product or service would be detrimental to the author, to you as an author's reputation or honor. And that standard is not a subjective standard in the sense of you're offended and that's good enough. It needs to be a standard where other authors would agree that the use was, or change or alteration or distortion was detrimental to you. There's also, and I'm not sure if it's relevant to anyone in this audience, but there's also people that are freelance writers for periodicals like newspaper do get a right of restraint. So when you are a freelancer and you write for a newspaper, you grant the newspaper the right to publish your work in association with a particular compilation or publication. And then you have the right to restrain, publication of that work outside of the context for which it was granted. Author and ownership issues. Give me 1 second. I'm sorry, my son is at the door. I'm presenting, Drew. Sorry about that. Author and ownership issues. So authorship and ownership are distinct, and it's very important to keep that in mind, particularly when it comes to the economic copyrights, where the owner and the author are often two very different entities. Employers are the first owners of works made by their employees in the course of employment in Canada. It's important to keep in mind that there is no work for hire concept in Canada. That's a US concept, and it often gets repeated in Canada, even though it doesn't exist here. It's really only employees in the strict sense of the word that create something in the course of their employment where the employer will be the first owner. Outside of that context, with very few exceptions, if any, the author will be the first owner and will have granted an implied license typically, but they retain copyright. That means that freelancers, contractors, consultants, workers on commission, with a few exceptions, pro bono workers are the first owners of copyright unless there's an agreement to the contrary. If you are a freelancer, you want to be very careful with the agreements that you enter. Most of them probably will have you assign rights, but presumptively you're the first owner if that agreement doesn't get executed, although you would have granted an implied license. So if you're hiring someone to create something for you, particularly in this gig economy, it's very important to keep in mind or turn your mind to whether or not an assignment is required for you to own copyright in whatever it is you're hiring someone to create. And the other thing to think about is, do you have or need to give a moral rights waiver from the author or as the author? So are you going to be using a work in association with things that may get an author or artist back up? And do you need a waiver of moral rights to ensure that you don't face a moral rights objection? Copyright ownership. I'm sorry, I'm repeating myself here. Author's first owner unless employee. In terms of transferring ownership, you can transfer ownership by way of an assignment, which means you are giving away your rights. An assignment must be in writing. You saying something verbally to someone else that says that you agree to assign it does not meet the requirements to assign copyright. It has to be in writing. there's no magic words. It can be, I give you all my copyrights, although that's not the usual language I use. But it is important to keep in mind that there's a big difference between selling a physical object and selling copyright in it. So if you are commissioned to create a artwork or something, and it's a physical something that you're commissioned to create, and you do not assign the copyright, then arguably, and there's a good support for this, in fact, all you've done is sold the physical object, and that person doesn't have the right to reproduce whatever it is that's sold, unless it's clear that there was an assignment of copyright that was associated with it. The other way that you can sort of grant rights is by way of a license, and a license is granting someone a permission to do something, and it can be implied, meaning it does not have to be in writing, although an exclusive license does need to be in writing. And I think one of the most important things to keep in mind, and if there's anything that you take away from this talk today, aside from a business name registration not giving you trademark rights, it's that if you grant an exclusive license, you are excluding yourself. A sole license, and for the transcription, it's SOLE. A sole license grants only one licensee. So if you're the author and owner of copyright in something and you grant a sole license to someone, you're saying, you are the only person I will permit to use this, but I also can use it. If you're granting an exclusive license, you're saying, here are all of my rights, and I agree that I will no longer exploit them. So an exclusive license is very close, and in fact is deemed at law to be akin in some ways to an assignment. So be very careful with exclusive licenses. When it comes to licensing, and it's could be a whole talk in and of itself, there's an entire collective licensing regime in Canada dealing with various different types of works and subject matter. Music, I think, is one of the areas where collective licenses are most vibrant, and that's in part because there's sort of a mandatory license regime for sound recordings in certain contexts, and in other contexts, it's actually a live issue as to whether or not collective tariff, or the tariff system and a tariff that's granted for use of a license through the collective licensing regime is in fact mandatory. Again, beyond the scope of today's talk, but it is important to know that there is a whole regime out there if you are a musician or another type of artist, to consider whether or not there may be a collective body that could assist you with licensing your works. Another huge topic relates to user rights. User rights in Canada are typically the right to fairly deal with someone else's work. In the US, the concept is fair use. It's important to keep in mind, and everybody wants to rely on user rights, parody, satire, taking a teeny part, sampling. All of these typically involve some form of reliance on fair dealing in Canada or fair use in the US. And it's important to keep in mind that it's inherently risky to rely on user rights. It's a smell test. There are very few, if any, bright lines. And there's two requirements from a Canadian perspective. Fair dealing first must be for a specific purpose that's prescribed. It can't be for any purpose. Those purposes are research, private study, criticism, review, news reporting, education, parody, or satire. And presuming you meet the threshold for one of those uses, the use also must be deemed to be fair. And there's a whole series of factors that will be weighed in determining whether or not a particular use is fair, including the true character or purpose of the dealing, the amount of the dealing, what were the alternatives to the dealing, the nature of the work, and the effect on the dealing on the work, the original work itself. This area of law is wrought with inconsistency or ambiguity. It's not easy to determine whether or not something will, with a level of confidence, be deemed to be fair dealing. So it's very important to be very cautious when it comes to this. In the US, fair dealing does not need to be, while they do consider the purpose as part of the fairness analysis, it doesn't need to be for a limited set of purposes. It can be for any purpose. And in the US, they also have this concept of transformative use, where if you use someone's work and you transform the meaning, that will also potentially qualify, provided the use is otherwise deemed to be fair. So user rights are the right for third parties that do not have a copyright interest to use someone else's work without permission. but they can be tricky and they can be difficult, so be cautious. There are other types of user rights. For example, individuals get the right to make certain private uses without permission, including time and format shifting. So that's why you can DVR things. And there's a specific exception for non-commercial user-generated content that is set out in the Act. So copyright dues, if you're working in a team environment, make sure that everyone's working in collaboration with you has a good handle on copyright, because someone else can very easily implicate you or get you into trouble. Create original content, be careful with parodies and satires and homages and taking inspiration from other things. On the inspiration side, be very careful with inspiration. Generally speaking, inspiration itself is okay if you don't copy a substantial part of a work, but you can infringe copyright by colorably imitating something, which means that there's no actual literal copying. You're not right-clicking, you're not taking a portion of something, but you're imitating it to such an extent that you've crossed a line. And that can happen without reproducing a single line or a quote unquote single brushstroke. So inspiration, you need to be careful that it truly is inspiration, and you haven't sort of moved into the zone where you're imitating whatever it is that you've taken inspiration from. You want to clear rights. Be extra careful with works that are in the public domain. The internet is not the public domain, you need to be very, very careful. The public domain and making assessments of whether or not something is in the public domain in Canada or internationally is a very involved and can be a very complicated exercise. And you also need to make sure that if you are relying on something in the public domain, that it is in fact the version in the public domain that you're using. So a simple example is for certain works in the public domain, if someone else took the work and built upon it, the part that they built upon may still have protection in it. So you can trip up quite easily. There's a case in the US that involving Sherlock Holmes, where a writer actually went to court to say, Sherlock Holmes is a free-for-all. Most of the works have fallen into the public domain. I should be permitted to create my own series of Sherlock Holmes books. And the court basically said, no, you can take the elements that have fallen to the public domain, so those core elements that are in the public domain, but you can't take the incremental elements that remain a source of protection, even if those were built on something that was in the public domain. So be very careful with the public domain. And get a license. There's tons of free or Creative Commons licenses that are available now. You should be aware of the requirements that are associated with the license, but do consider licensing, when in doubt, and sometimes it's cheaper to ask for forgiveness than permission, but when in doubt, ask for permission. From a copyright perspective, you want to use copyright notices, technological protection measures, as well as digital watermarks or other digital rights management information. So you can use embedded lines of code to tell people the copyright terms that travel with your work. And Creative Commons actually will shortcut and provide you with a way to attach that type of digital rights managed information to your works. If you are making something available in a digital context, supplement with terms of use or a contract. And if you're dealing with something in the real world, supplement with an agreement. If you're creating something with someone, distill very simple terms that govern. So you have not just your copyright claim, but you have potentially a contract claim. And give or you are, commenting or criticizing something, you do. Whoops.
We lost you for a little minute there. Can you just repeat yourself?
Yeah, where did I lose you? Did give credit, cite the source?
I think so, yeah.
Okay. So for some of the fair dealing exceptions, you do need to actually attribute. So for criticism or review and news reporting, you need to actually name the source of the work that is associated. So, and within particular academic context, it is important to, from a sort of a plagiarism perspective, which is a different animal and outside the copyright box, to credit and cite the source. Copyright don'ts: do not right click, do not copy and paste, avoid that as much as possible. Don't tamper with or disable digital locks or remove rights management information. Don't presume that other people doing it means you can, or that you've only taken a certain percentage and that means that you should be in the clear. And don't assume that crediting is enough. So assignments versus licenses. And so whenever you're dealing with someone and they're looking to buy out some of your rights, think about if there's any of the rights that you can retain. If their use is only going to be in a particular medium or in a particular territory or deal with a particular right, try to only sell those and retain the balance of your rights if you can. Licenses also should be by territory, right, or medium. Avoid blanket grants wherever possible. I already mentioned the exclusive sole or non-exclusive. Please do keep that in mind. It's quite important. And whenever you're looking at an agreement dealing with the grant of rights, again, think of the scope of what rights should be dealt with and try to limit the agreement to that particular scope. On the other hand, if you're the licensee, try to get everything, because it's safer to get everything if you can. All right, agreements. So just from a very high level, when you're looking at an agreement, here's sort of a checklist of things to run through. Who are the parties, or the right parties named? It needs to be legal entities. If someone is not incorporated, make sure that you use their personal name and add carrying on business as XYZ Co. What is the subject matter of the agreement when you're dealing with intellectual property or some other grant? What is the subject matter, and have you defined it squarely enough, or is it too broad? What rights are involved? So we already touched on this. If you're, granting rights for something to be produced or live performed, you don't need to grant the digital equivalent unless it's also going to be broadcast, and make sure that you're granting rights in a way that reflects that. What, how, and when will you be paid? And think about all of those factors. What amount? Is it a royalty structure? Is it a lump sum payment? Is it a revenue share? When? What's the timing? Will you get advances? How will the advances be set off against later payments? How will you be paid? What is the general term? Make sure that you've sort of boxed in what the term is. And can you get reversionary rights? So if you set a particular term, will there be milestones that need to be reached? And if those milestones aren't reached, will your rights revert to you? How is liability managed between the parties? This is a big one. Are you providing something as is, where is, without and disclaiming any and all warranties express or implied? Or are you warranting that the work is original, it won't infringe anyone else's work? And if you're doing the latter, is it to the best of your knowledge and belief, or is it blanket? I would encourage you, in many situations, you will need to provide a representation and warranty. But minimally, that representation and warranty, I would encourage you to make it to the best of your knowledge and belief. So not a blanket representation and warranty, but not a blanket representation and warranty that you warrant that for sure you're not infringing anyone's rights, but that to the best of your knowledge and belief, at whatever the time is you're signing the agreement, you're not aware of any infringement claims and you're not aware of any liability. It gives you a bit of sort of risk mitigation. Are you indemnifying? And indemnity is you telling someone else that if someone sues them for a series of things, you will defend them and you will pay for their defense. You will cover the claims and you will cover their exposure. If you are providing an indemnity, you should be very mindful of what the scope of that indemnity is. There's a whole series of terms that you should think through if you are providing it, and you should think about getting insurance, frankly. Any indemnity, in my view, should be backed by insurance. What territory is covered? Is it a worldwide agreement, and does it have to be, or is it limited to Canada? How and where will disputes be resolved? And what's the jurisdiction of the agreement in terms of governing law? Is it Canadian law? Are you agreeing to go to Ontario courts? Are you agreeing to mediate and then arbitrate? How will fights be resolved if you're there? Oh, and back to liability, is there a cap on liability that for every claim, they agree that or everyone agrees that it's only worth $100 per what have you. And can they get an injunction? Can they stop your activity? So depending on the nature of a particular agreement, you want to make sure that there's no available or no way to cancel the grant of rights. When and how can termination occur? So what are the outs? How do you pull the parachute? What are the triggering situations where you'll be able to exit the agreement and get out of the agreement? Is it just notice on 90 days notice? What happens on termination? Do rights revert? Are rights irrevocable? Think through all these things. If the relationship falls apart, what's going to occur? Who are the beneficiaries of the agreement, and can the agreement be assigned to successors? Can you transfer the agreement to someone else? And if so, does someone's permission need to be granted in order to do that?